Days in Africa that we are hosting in conjunction with the UNCITRAL. By way of background, we have had this is the fourth in a series of UNCITRAL Days that we've been hosting in together with UNCITRAL, with the Mandela Institute and UNCITRAL. For those that have not been had an opportunity to attend the other 3 series, basically the main theme was inclusivity, economic inclusivity in the wake of the CFTA. The first one focused on inclusivity and harmonization of laws, of course, with regards to also SMMEs, because generally we tend to issues of trade. Normally, sometimes in Africa, we tend to forget that SMMEs actually are the ones that drive trade. Then the second UNCITRAL Day focused on stronger SMME participation, but looking at how to improve credit access for SMMEs also. Then the third focused on intra-African trade, but with the bias towards e-commerce. So today the focus is really on looking at, and we're still focusing on the element, on the theme of inclusivity, but mostly focused on dispute settlement and how advisory centers could help in this regard. So we are really privileged to have Your Excellency, the Secretary General of UNCITRAL, Ms. Anna Joubin-Bret. I hope I'm pronouncing that properly. So in terms of how we will do this is in terms of sequencing, Ms. Anna Joubin-Bret will give us a 5-minute intervention or giving an overview of how these days came about, the UNCITRAL Days, and the work that UNCITRAL is doing around this. Then after that, we will have Ms. Kholofelo Kugler. She's a lawyer at the Advisory Center on WTO law in Geneva, and she's also doing a PhD on issues around IT and the Fourth Industrial Revolution and regulation. So she will also give us their view from that side on how advisory centers could have a role to play on this. Then after that, we'll have Mr. Jae Sung Lee. I hope I'm pronouncing that correctly. From UNCITRAL. So he will give us an overview of the work that UNCITRAL is doing with the idea of having an advisory center on international trade and investment law. Then after that, we'll open the floor for discussion and questions. And over to you, Ms. Joubin-Bret.
Thank you very much. I'm delighted to be joining all of you for this fourth event hosted by the Mandela Institute at Wits University. I'm very grateful to Professor Bielefeld, who has been coordinating these activities so far, and I'm also very grateful and honored to be sharing this webinar with an old friend of mine, Azwimpheleli Langalanga, who's been with me that I've known for, I shouldn't say how many years, and Miss Kholofelo Kugler. It's very nice to see a colleague, a trade lawyer, who is going to share the experience of the ACWL, and she will explain more about that. So a warm welcome to all of you participating in this fourth event, which is part of our UNCITRAL Days in Africa. Just in terms of background and very quickly, the UNCITRAL Days are a flagship annual series of events that we in the UNCITRAL Secretariat co-host with institutions of higher learning. They are meant to celebrate the establishment of UNCITRAL, and UNCITRAL is an old lady, born in 1966, so it's becoming more and more of a celebration. We are aiming at promoting awareness discussion, of course, of UNCITRAL texts, but also UNCITRAL topics of current work by young legal scholars, students, the next generation of legal thinkers, policymakers, and we hope also, and that is our hidden agenda, future participants and contributors to our work in UNCITRAL. So we have these UNCITRAL days since 2014 in Asia and the Pacific. And since 2020, we have the Latin American and Caribbean UNCITRAL days, which are selling like hot buns. We have 30 more partnering universities who are, for Latin America, we had, this year we're expecting 16 jurisdictions, sorry. So what was missing was really days, UNCITRAL days for Africa. And I'm very pleased that our commission, the UNCITRAL Commission, put that on our agenda in 2021, and we launched the first edition of the UNCITRAL Days in Africa in Accra, in Ghana, with the Ministry of Foreign Affairs and with the support of the European Union, and that was really a great success. At this launch event, we had the pleasure of the participation of the Mandela Institute, and it's really great to see that so many different participants from one session to the other are joining, because it broadens, of course, the outreach for UNCITRAL on its existing texts, but also, and that is the focus of today, the discussion on the current work of UNCITRAL. And here we have, in fact, and that's what really makes me very pleased, we are discussing one of the reform elements that are part of the broader reform of investor-state dispute settlement mandate that has been given to UNCITRAL, and that UNCITRAL has now subcontracted to its working group 3, which has identified over the last 4 years a number of elements of reform, having first assessed what the problems are, what the concerns with the system as it is working currently. Hello. Yes, thank you. And so we have, of course, the working group has identified a number of other topics or elements of reform that are being currently developed. My colleague Jae, who's the secretary of this working group that works on these reform elements, will talk to you, I'm sure, also a little bit about the code of conduct for arbitrators and adjudicators, the work we're doing to establish an appellate mechanism. We will be talking at the end of the week in a broader context about the multilateral investment court, first level and second level. We will be talking about the reform of procedural elements. So there's a lot going on, and I'm particularly glad that there is focus on one element of reform that is particularly keen to my heart and my work, the establishment of an advisory center on international trade and investment law. So this advisory center is not a new idea. It's an idea that has been floating for many years. Already when I was still working with UNCTAD, and at that time we had developed or quite advanced actually an advisory center for Latin American countries who were just beginning to be targets of investor-state disputes. And now we are broadening it to the entire group of countries that are participating in the reform discussions, and of course with a special focus on developing countries. So Jae is going to explain all of this to you in detail. I am very much looking forward to the discussions and also about the, of course, the experience of the ACWL that Kholofelo will present, because it has been a blueprint for us and we have exchanged a lot with our colleagues from Geneva. But before I give over to Azwi and to my colleagues, I just wanted to precisely thank these colleagues for pulling it off with the Mandela Institute, particularly Miriana Belaj, who is the coordinator of our UNCITRAL Days, Cheryl Dine, who's been helping out a lot, and Jae, of course, who will be presenting for this session. I look forward to seeing you at the end of the week in person in Johannesburg at your university. And in the meantime, I give over to you as you will guide us through the discussions. Thank you very much.
Thanks a lot, Anna, for those remarks. We'll now move to Kholofelo to give us an overview from the ACWL side on how they look at this issue of establishment of advisory centers when it comes to an institution like the AfCFTA that will definitely need some capacity in that regard. Over to you, Kholu.
Thank you so much. So I will share my screen and hope that you can see.
I think that Kholo is frozen, which is not a surprise because it's very cold here.
Yes. Hello, Kholo. Yes, I think there is some.
Oh, there she is.
Ah, there we go.
Okay. Okay. Hello, can you hear me?
Yes, we can hear you.
Okay, I might have some connection issues. Let me just try. If not, I just need to change the location of the Wi-Fi and probably use my mobile. Please excuse me. I'm in a building that has notoriously bad internet, so I hope we can make it through this presentation.
We can see the presentation now.
Okay, perfect. And you can hear me?
Yes.
Yeah, we can hear you.
Okay, perfect. Thank you so much. I do apologize in advance for any disruption. I will try to minimize. All right, so it is a pleasure to be presenting the ACWL, which is the Advisory Center on WTO law. My presentation will develop as follows. The objectives of which was to be understand why the ACWL was created, understand the mandate, the institutional structure, and the funding. And then learn about which countries are entitled to ACWL services. And then this is when we will see how the African countries who are signatories to the AfCFTA or future signatories to the AfCFTA might be able to benefit from the ACWL's services. And I will cover this, just talking about the background of the institution, the mandate, the members and LDCs, the services provided by the Advisory Center on WTO law, and a little bit on the administration and a little bit on the staff. So basically, this institution dates back to 2001. As you know, the WTO was established in 1995, and very soon after the establishment of the WTO, it was seen that without any intervention, the current inequalities will be entrenched in the system because developing countries will not be able to take full advantage of the Marrakesh agreements and obviously the underlying agreements thereunder. The 1999 Ministerial Conference in Seattle, also known as Battle in Seattle, or where the Battle in Seattle took place, really underlined, this fear that the WTO might not be fit for purpose for developing countries, or developing countries might be left behind. And so very soon after that, in 2001, the ACWL was established. So basically, ACWL is not part of the WTO, although there is some sort of mention of this capacity in the DSU, but it's not within the WTO. It's not part of the UN. It is its own standing organization in Geneva that has a host agreement with Switzerland, like the WTO and the UN. So basically, in a nutshell, it's an intergovernmental organization which was created with the following mandate: to provide LDCs and developing countries with the legal capacity necessary to enable them to take full advantage of the opportunities of WTO membership. And there are three services which this organization provides. It's legal advice, WTO dispute settlement support, and training. Just to give an indication of the legal advice, 213 opinions are given every year, with the average, this is the average between 2011 and 2021, when the numbers were really captured, the data was captured from that date. So far, the ACWL has been involved in 70 disputes as of December 2021. So this is the full-year statistics. And also the training that has completed in-house is 20 annual training courses and 17 secondment programs, which I'll discuss in a bit. So basically, how does this organization operate? As I said to you, it is non-political, it's independent, and it's a source of legal advice for developing countries and LDCs. So there is this concept of no ambulance chasing. Basically, the ACWL provides a service on demand, so on request of the developing country member or the LDC. It follows a principle of neutrality, basically meaning that it only provides legal advice, not political or strategic advice that is not legal in nature. So it's really to try and ensure that the ACWL is neutral. The ACWL also does not take positions on any part of WTO law, the negotiations, or anything that's going on currently in, whether it be the current, for example, the services waiver, not the services waiver, the TRIPS waiver, or whatever that's going on right now, completely impartial. And also, of course, as any legal office, the advice is strictly confidential. Now, the members of the ACWL are as follows. They are developed countries, so you might be surprised to know that there are developed countries who are members of the ACWL, but those are not the beneficiaries. They're basically to provide funding. The developing countries and LDCs, and the developing country members actually have to accede to the ACWL, and we've divided them into categories A, B, and C, depending on the share of world trade and per capita income. What's interesting to note is that 2/3 of the developing country members that have participated in WTO dispute settlement proceedings since 2001 have become members of the ACWL. On the screen right now, we see which are the members of the ACWL indeed. As I said to you before, there are developed country members, so there's 12 of them. We have 9 original members. You can see them on the left in fuchsia. And there are recent joiners like Switzerland in 2004, Australia in 2011, and Germany in 2021. What's interesting to note about Australia, for example, is that just very soon after it joined in 2013, 2014, some of the members of the ACWL, including Cuba and the Dominican Republic, initiated dispute against Australia's plain packaging measure. And so you can see that the developed country members that have joined the ACWL are very committed to the membership of this organization, and they do not really, contribute to the organization based on whether members can litigate against their measures or not. And also worth noting, Germany is also very active in the dispute currently between Colombia and the EU on anti-dumping measures on frozen potatoes. So what's interesting, probably for us, more interesting maybe, is that 39 members have joined the ACWL. So there's basically also submitted, instruments of ratification. And there are many members, as I said to you, they're divided into 3 categories, A, B, and C. There are many also African members. Kenya and Egypt were original members, but subsequently members such as Mauritius, Seychelles, South Africa, Morocco, and Cote d'Ivoire have subsequently joined. South Africa joined in 2017. So that is, one of the more recent joiners of the ACWL. And for your interest, also 35 members of the WTO are LDCs, and there are 8 that are exceeding. And of course, all of these are subject to, or they are beneficiaries, or they can benefit from ACWL's services. So what's interesting from an African perspective is that 44 out of the 54 African countries are WTO members. And as you can see on the 8 that are exceeding, quite a lot of them are African as well. So this means that basically every African country would have access, well, including most of the LDCs, will have access to the services of the ACWL. And also 44 countries have ratified the AfCFTA, meaning that a large portion of African countries would also be WTO members, right? So there's a lot of complementarity between the ACWL membership and the WTO membership. And although there's some members, obviously, that are WTO members that are not ACWL members, the ACWL has done it so that actually members can request legal opinions in groups. It could be in regional groups, or it could be, in whatever sort of negotiating groups. For example, if South Africa, as a member of the ACWL, requested a legal opinion that might affect SADC, that is completely fine. And so other countries who are in SADC, for example, Namibia, would be able to get the benefit of this advice. Namibia and Botswana, who are not ACWL members. So I just want to quickly move through that 82 countries right now are, entitled to ACWL services. And these are the 3 services that the ACWL provides: training, legal advice, and dispute settlement support. The training obviously is something that might be very beneficial to AfCFTA members. Just for your information, you might not be surprised that there's a lot of complementarity between the WTO agreements and the AfCFTA agreements and protocols. And so to the extent that there is a link, which there is very much a link, we would be able to provide training on WTO issues, which also happen to be AfCFTA issues, especially on the trade side, right? Just for the ACWL, they have their own Geneva-based training course in which 630 some delegates have already received certificates of training over the years. There's an annual training course that's going on right now. And for the first time since the pandemic, this year's course is in person. So what happened during the pandemic at some point that there were some capital-based delegates that could join in. And so this is actually something that could be explored with countries going forward in providing training remotely, which was actually quite successful when you think about how, so for so many years, this training was actually in person in Geneva. And of course, because of the pandemic, everything had to go remote, but it still worked very well. And we still had attendance of about 40 to 45 delegates in the training course, which is actually quite comparable to what the in-person courses used to be. Another session is a women's discussion group. We noticed that a lot of women tend to hold back in the bigger group. And so we created women-specific groups to speak about issues of interest in trade, and also the specifically more technical issues that women might be sort of shy to ask about in bigger groups. And also development is the thematic sessions in French. Of course, for Africa, this is very, very important and interesting because there are many Francophone countries which would be able to provide training to. All of them, everybody, there's people in the staff complement that speak English, French, and Spanish. And also for interest, there's ad hoc training that also could be provided. Let me just move on swiftly to legal advice, which could be of interest specifically. Now, the ACWL provides as I said to you, legal advice in all aspects of WTO law. And as I said to you, there's also very close complementarity between the WTO law and the law of the AfCFTA. So this is definitely an issue of exploitation of African countries where they can, obviously, as I said to you, the ACWL does not ambulance chase. So to the extent that there is demand for legal advice, they can, of course, request that legal advice from the ACWL. And it's also very sort of informal, as formal as you'd like, sending an email, contacting the office in Geneva. The ACWL is always happy and able to assist. And advice is given in all aspects of the law. It could be measures that the country wants to implement themselves, trade barriers that they're facing, or it could be an issue of negotiation. So there's really a lot that is, available for countries. Just for your interest, almost 3,500 legal opinions have been given over the years. At the ACWL, especially since the legal opinions have been the data has been collected. So it's not from day one, but from 2005, as you can see. And then last but not least, I'm just going to say a few things on dispute settlements. Of course, this is sort of a bridge further than what the legal assistance that we're talking about, but just to give you also an indication of what could be possible in partnership between AfCFTA countries and the ACWL, is dispute settlement in trade law. So the ACWL supports members from the very beginning in providing legal advice through to consultations at the WTO, the adjudication, also the implementation. So this is really the full flow of dispute settlement support. You'd also be very, very interested to know, you already know, that the DSU, the dispute settlement understanding of the WTO, is very similar to the AfCFTA dispute settlement protocol. The appellate body at the WTO is also called the appellate body at the AfCFTA. So there's a lot of complementarity that can work in the favor of African countries. And just for your own interest, if ACWL were a standalone country, meaning all the members that have been involved in WTO, the ACWL would be the fourth largest user of the WTO's dispute settlement system. So there's a lot of disputes going on and a lot of support that has been provided to developing countries at the ACWL. Just for interest, the fees that are charged by the ACWL are much lower than what is charged on the market right now. The fees are provided there on the screen. I am more than happy to provide you with this presentation so that you can see yourself, what discounted fees the members are eligible for. And then just last but not least, I just want to, this is just sort of the administration and funding. The ACWL's budget is very lean, although the endowment fund seems to be very big at 4.6 million. It's not really. And you really, the organization really depends on development partners for funding. But the staff is also very lean, with 13 lawyers and 3 administrative officers. And then we have 4 secondees that come from developing countries and LDCs. And there I am in my red jacket. So this concludes my presentation. If you have any questions, please feel free to ask me. And you're always welcome to go on the ACWL's website to peruse. Thank you very much. I look forward to the discussion.
Thanks a lot, Kholo, for that presentation. It is quite informative. In the past, I just thought maybe the ACWL is there to provide advice with regards to litigation. So I didn't know there was a lot of other whole suite of advice that you provide. But we'll come back to the discussion where I will, for instance, want to understand if you have been approached by the CFTA already to provide some advice, or if you actually do provide advice to other regional institutions or other regs, so that the CFTA itself does not have to look like it's special in that regard, that it has to, if it is practice that you provide that kind of advice. We'll now move on to our colleague from UNCITRAL, Mr. Jae Sung Lee, who will talk more on the proposed advisory center on international investment law. Mr. Jae.
Yes, can you hear me and
yes.
Can you see my slides?
We can hear you.
All fine.
Okay.
Yes, we can see your slides now.
Good. So it's good that Kholofelo went before me, because she has been able to present to you what has been set in stone in the ACWL, which has become, as Anna mentioned, a blueprint for our discussions in UNCITRAL on the possible establishment of an advisory center, but on international investment law. So it's quite different in the sense that the subject of the matter is not WTO law, but it is international investment law. And as mentioned by our Secretary of UNCITRAL, it is one of the key elements of the reform that UNCITRAL is pursuing. As mentioned, we do have a lot of other reform elements on the table, but they're all interlinked in the sense that some of the advice at the Advisory Center could actually facilitate some of the other reform elements which are being discussed by the working group. Just to let you know where we are on, how I can go to the next slide. The working group itself, the working group 3, is the working group that has been mandated by the Commission to discuss its reforms of investor-state dispute settlement, has had 2 sessions of discussions on the possible establishment of an advisory center. So first, we discussed the idea, And then at the recent session, on the 43rd sessions, we also received some further instructions on how to develop draft provisions on the advisory center, which would likely become part of the multilateral investment on investor ISDS reform. So that's where we are. So we're currently looking into the structuring or the design of an advisory center similarly and based on what Kholofelo has been able to provide us on the ACWL model. Now, why is the advisory center being pursued? Because as Anna mentioned, we have identified a number of concerns that need to be addressed, and we're hoping to address the cost of the ISDS proceedings, which is quite high for developing countries. We're also trying to target correctness and consistency of the decisions and possibly access to justice for those who are not able to access the current ISDS regime because of the high costs. We also hope to use the advisory center to enhance transparency. And as mentioned, the establishment of the advisory center would be linked with a number of the other reform elements that the ISD Working Group 3 is pursuing. If you look at the provisions that we have provided, it actually follows what Kholofelo has mentioned. We have to first define what the purposes of the center is. Second, what kind of services that we'll provide. Who will be the beneficiaries of the advisory center, how it will be structured, as well as the operations, and what's it going to cost, who's going to pay for it. And we have also prepared a budget models, some different options on how to establish a model. And we have a similar figure as Kholofelo mentioned with regard to ACWL. Now, on the purpose of the advisory center, I guess we need to identify what the general services are and the beneficiaries are, what the overarching principles are, which also Kholofelo mentioned. I guess the independence and impartiality of the center, reliability, accountability, and it also relates to a number of the services that, or the kind of services that the advisory center would be providing in this area. There has been focus on two different pillar structures. One is focusing on the assistance mechanism, which is geared towards states. And another aspect is a forum where states and other involved in the ISDS, because in comparisons to the WTO law, you must understand that the other side of the ISDS regime is that there are investors who are raising these claims, and therefore it's not only states that participate in the ISDS regime, but there are also investors. So we're also envisioning a forum where there could be sharing of information, exchange of information, and also learning based on the past experiences of the states. So these are the two basic pillars, structures of the advisory center that we have envisaged. Now, Kholofelo has highlighted what kind of services the ACWL provides. Now, as we are planning for the advisory center on international investment law, we're looking into different services, whether the advisory center would provide advice in the pre-dispute and dispute avoidance. This is also a very important factor to actually avoid disputes from arising at the very early stages, whether they would be able to provide services with regard to non-arbitrations, so mediations and other ADR. Another key issue that is being discussed is whether they will have a role in representing the states in the ISDS regime. Now, the latter part, some concerns were raised about the advisory center providing legal and policy advisory services because of the fact that Kholofelo mentioned there may be actually conflicting aspects when you provide policy advice and then also represent the states in the actual cases. Capacity building and platform for sharing best practices. As I mentioned, this is a key role of the forum aspect, but there's also been inputs from developing states that there are other institutions that already provide capacity building and platform, and maybe the focus should be more on the representation services and direct assistance. So that's kind of where we are. Now, as I mentioned, the beneficiaries, we have a slightly different issue, because compared to the WTO law, where the two disputing parties are both states, in the case of an ISDS, a claimant is usually, and in most cases, an investor or a corporation. So would these investors also be able to benefit from the advisory center is a question that is being raised. Now, before I get to that point, now, if we go to the beneficiaries as states, and as Kholofelo already mentioned, it is not probably going to be possible for the advisory center to provide all of the requests that they have received. They need to prioritize among least developed countries, developing countries. It might be a first come, first service, first served model, but there needs to be some sort of a prioritization between who will get the services of the advisory center. Now, going to the other side of the coin, I think there's been more preference that the advisory center should be geared toward providing beneficiaries, providing states services. But the question of whether the advisory center could possibly provide advice to small and medium-sized enterprises who do not have the funds to actually access the ICS regime is being discussed in the working group. So that is also a question that the working group is currently addressing. Of course, when we get to priorities, how to define developing countries, how to develop least developing countries, whether it's going to be something based on the UN model, whether, I mean, we do have a different membership than the WTO, so who the memberships would be is also something that we will need to consider in that context. Now, if the establishment is to be conducted, the structure of that advisory center is first to be discussed. As Kholofelo mentioned, one possibility is to have it as an independent intergovernmental body, or a cost-effective way is to host it with an existing body, possibly having some synergies and actually saving costs about resources and connections. Of course, there may be issues about trust between the linkage between the advisory center and the hosting body, and therefore, I think the preference in the working group has been to develop or establish it as a separate independent organizations. But we are in the preliminary stages of how to go forward on this aspect. Now, membership, as I mentioned, is also something that we have to consider. Would it be open to all UN member states? Would the members then be responsible for paying certain fees for the operations of the center? Would the beneficiaries be limited only to member states? Is all of the issues that we're considering, and the impact that this membership would have on independence and impartiality is something to be considered. Now, if the beneficiaries are to be also MSMEs, whether they would be a member or whether they would be able to benefit from the services but not actually be a member is also something that we're considering. Where to locate the advisory center, what kind of offices, possibly having regional offices is also being considered. And a lot of emphasis has been made to make sure that the operation of the advisory center is sustainable and is able to reach out to a large number of states, which is the topic of today, being inclusive to all of those who are involved. Now, it all might boil down into how much money we have, what kind of a financing structure that we'll have in order to establish the advisory center. The ACWL has been definitely a model that we have been looking into. Whether it will be the funding would be gathered or collected through the memberships, where the members would be paying for it. Whether it will be somewhat a mixture of fees being paid by those who are using the services, and possibly combination of the two is something that we're looking into, as mentioned in the slides, that we're kind of looking into the ACWL financial structures. And you have to see the other side of the coin on how much the advisory center will be charging for its services to the developing countries that are going to be the beneficiaries. So we had done a joint study with a group of experts on the possible estimate of a budget, and we have come up with a figure of 4.2, more of a reasonable figure to kickstart the establishment of the advisory center, and possibly a lower figure of 3.1. And of course, as the advisory center is developed, we may actually need to take a phased approach where the services are expanded, the beneficiaries are expanded, as well as the budget and the expenditures also being expanded. So other things that we're looking into, whether there will be a membership fee, whether we'll be open to receiving voluntary contributions from others, possibly investors who are involved in the ISDS regime, whether the users would need to pay a fee, how much they would be paying, and all of those things are related to the sustainable operation of the advisory center that I had mentioned. So I think what Kholofelo has mentioned with regard to ACWL shows us that the ACWL could be a model, but in the blueprint for what the UNCITRAL is going to be preparing in the establishment of a possible advisory center for international investment law. But we are looking into different options because of the differences that exist between the WTO context and the ISDS context. So with that, I think the most recent paper that we have established, we have prepared in the topic is trying to unshare, is working paper 212, and then the one which actually contains the budget figures for the possible establishment of advisory center. All of these working papers are available on UNCITRAL's Working Group 3 website. So please take a look. And as Anna mentioned, currently the next session of the working group is going to take place on in January of this year, January of next year, which will be focusing on a code of conduct and an appellate mechanism. And then a following session will be held in March of 2023, looking at draft versions on mediations and the possible mediation guidelines. So all of these reform elements are continuing to be considered in parallel by the working group, and we look forward to your participation in that discussions as well, and possibly for AfCFTA to kind of piggyback on the developments at UNCITRAL and vice versa. Thank you for your time, and I would be happy to answer any questions that you might have.
Thanks a lot to Mr. Jae. We really appreciate your presentation. I think it's quite informative. Definitely a lot of questions around that, considering that if you look at the ACWL, there is the WTO, there is a compendium of WTO law, which is accepted as law, and investment law, we kind of still have a situation where we have sort of a contestation of where do we really locate international investment law. So I think there is a lot of complexities there. But before I open up the floor for questions, I think I have a question for Kulu, which I already kind of highlighted. Do you currently provide any advice to regional economic communities, considering that the FTA itself is really a regional economic community? And maybe while Kulu is responding, I'll then give Mr. Jae some questions or remarks to think about. I've already alluded to the fact that international investment law itself is not, we don't have a sort of a codified or an agreed set of rules and regulations that are deemed to be international investment law. And currently we have the ICSID as the main center where these kind of disputes are taking place. Would you then maybe assume that this, or envisage locating the advisory center on international investment law around the ICSID itself, or considering that there are a lot of fora where these disputes might be taking place? And considering that there is no multilateral agreement on investment, is the envisaged institution, have you thought of which kind of laws and regulations you will kind of stick to? I know Anna, while Anna was still at UNCTAD, she did some work in trying to codify international investment law, which I think really laid a good groundwork for this kind of thing. But back to you, Kulu.
Thank you very much, Azwi. That's a very interesting question. But I just want to remind you that the basis of our membership is a state or countries. And so although the ACWL has not directly provided advice to a REC or a regional integration per se, there have been issues that have been raised in the regional integration arrangement that was raised by a member, which then we provide. This has happened in the case of African countries, the specific measures that AREC wanted to adopt. It happens very, very often in the context of Latin America and also in the ASEAN or in the Asian context as well. So we do not sort of exclude, that type of advice, but because as of yet, a regional group or FTAs or RTAs, the institutions cannot be members of the ACWL as such. That's how we work. And it's been very, very, successful, that model. And we've also used that model actually in dispute prevention. As Jay was mentioning before, you provide a legal opinion in which the member would then share with the possible, litigant, co-litigant, and they have used that legal opinion sort of to provide to solve their issues in that way. So I think there's many models, or there's many ways to skin a cow, and this does not preclude obviously members who are AfCFTA members to find a solution to a specific problem at the AfCFTA.
Okay, thanks. It's good to hear that there is room for innovation around this. Yeah, and Jay.
Yes, thank you for posing that question. I mean, as I mentioned, there's a slight difference between the WTO law and ISDS context, in the sense that, as you mentioned, the WTO law has a set of big treaties or laws that apply to WTO disputes, whereas if you look at the ISDS disputes, there is a wide range of scattered investment treaties, and new treaties are being negotiated also with different language. So the expertise that are required by the advisory center probably would need to be a little bit broader than what's currently in the ACWL, in the sense that the applicable law or the applicable treaty may differ. So this is something that we do have in mind. Now, as to whether this can be hosted by the ICSID, you must understand that ICSID does have technical assistance and also support activities and capacity building activities that provide such services to developing countries. Now, if the services of the advisory center is to be representative, we may actually have to separate it out and make it as an independent organization in order to ensure that there are no conflicts of interest. And I think that's why I tried to mention that during my presentations. But in that sense, if the focus of the services is to be representation, it might have to be a separate independent organizations rather than being hosted in one of the, ICSID is the largest organizations that handles or administers ISDS cases. So of course, ICSID might be the most favorable candidate, but PCA may also be able to do it. And there are a number of other institutions that provide capacity building. So what we want to do is to avoid duplication of services and to focus on one of the key services that is to be provided by the advisory center. And once that's decided, I think it will be able to decide where to host this advisory center. I think that's something that we need to look into.
Okay, no, thanks a lot. I think that's quite clear. Now I'll open the floor for questions from our audience. So there's already a question from Tsitsi, and she says, this is directed to Kholo. She wants to understand if a country is not a member of the ACWL, can they not get help in terms of litigation from the ACWL?
Yeah, so just to go back, LDCs would be eligible at all times for all the services. So whether they're training, legal advice, and litigation services. At this stage, we only provide litigation support to those members, those 39 developing countries that are ACWL members. And I just want to sort of clarify one thing that maybe I might have not been so clear in the presentation. We charge very little, fees for litigation, but all the other services, legal advice and training, are completely free of charge for members, all members, including LDCs. So to answer your question, no. But because the scope of LDCs is quite broad, if they needed advice, would be able to. Litigation support would be able to provide that to them.
Thanks for that, Kholo. I think we've MJ, if there's a question. MJ, you may unmute yourself and ask your question.
Thank you, Azwin. Martin Jarrett here from the Max Planck Institute in Heidelberg. Hello to everyone. I can't see myself on the screen. I have turned on my camera, however. So can you confirm that you actually see me? Okay.
I can see you, but it's frozen.
Okay, you're all moving to me, so it must be the Wi-Fi connection. And actually, I feel a bit underdressed because I'm looking at you, three of you on the screen here, and you're dressed in nice suits. And honestly, I just wanted to get a fresh change of clothes on and get into my hotel room. So excuse my informality. It's no disrespect. Jae, I think you've been like tickling the issue that I have been wanting to ask you about. I'll say this generally, I think that an advisory centre is definitely a good thing. Who could not be in favour of it? But of course, we have a task to be somewhat critical. And I'm worried about the very fragmented nature of international investment law. You mentioned that, like, in comparison to international trade law, let's say, of course, the substantive law is made up of thousands of treaties. And even though, yes, there are similarities, as we see now, more modern treaties are starting to tweak their provisions a little bit. They're not prepared to go copy, paste, and then change the names and sign it at the bottom. But also, as the reform process goes along, it might be the case that the procedural side of international investment law also becomes fragmented in a way that we haven't seen before. So it's really becoming a very fragmented area of law, which, as you mentioned, requires a lot of expertise. And my question is, given all of this fragmentation, is there a point where you have to say that the advisory centre, for example, it only deals with investment treaty disputes that are subject to any new multilateral investment court, and as regards other investment treaty arbitrations outside that multilateral court, we just don't have the capacity to deal with those. So that's basically the gist of my question. It's getting more fragmented. The more fragmented it gets, the more knowledge you need to bring in, and of course there are capacity constraints. So are there thoughts in the future of saying we are going to limit what our services can actually provide for the states that want them? Thank you so much.
Thanks a lot, Martin. Jae, as you respond maybe to Martin, you may also start to give maybe closing remarks, and Kulu, you may also start to come in after Jae. And I'm not sure if Anna is still with us, then she could also come in, then we close the session.
I think Anna has left. On response to Martin, I think your point is very realistic. And I think from the Secretariat perspective, we're also trying to take a very realistic perspective of what can be done. Of course, we want to be idealistic to provide all of the services that you would require, even in the fragmented nature. And if you get down to the point, there is also this issue about whether the mandate of UNCITRAL should be broader to that actually harmonize the substantive law issues of ISDS rather than only focusing procedural reform. Now, this could go in different directions, but you have a point that we have to have a realistic approach. And even in the working group, we're discussing whether the services or to be provided by the advisory center should be limited at least to treaty-based investor-state disputes, because there are contract-based disputes, there are domestic law-based disputes, and then if you want to widen all of the services to where even when the treaties are fragmented, and then you go into even investment contracts or domestic laws, this just makes it too much of a big services that the advisory center has to provide. So as we progress forward, of course, we need to expand the services that we have, but we have to keep in mind what can be done and what kind of services need to be done. And I think there is really a need to have the working group discuss what the priorities should be. And as you mentioned, I think it should start only from treaty-based disputes, whether it's only for the multilateral disputes that arise from the recent treaties, or whether it's to those certain number of states that are members of the advisory center that should be focused on. We'll have to see where that's going to lead us. So we are quite in a preliminary discussions, and as I mentioned during the presentations, we'll be happy to hear from get all of your inputs on where the advisory center should be heading. That's kind of the closing remarks.
Thanks a lot, Jay. We have a question for you, Kulu, as you close from Faith Together. It says, as the African Union notified the CFTA, I understand there are two options in the GATT Article 24 and the enabling clause. As the AU approached the ACWL for legal advice on this, if not yet notified?
I am not quite sure if the AfCFTA has been notified in the WTO. I haven't checked, but we haven't received a request for notification. But if anything, I don't know if it would be notified under the enabling clause or the Article 24, because it's quite broader than just a goods only agreement. So it'd probably be going to, something like Article 24 of the GATT and Article 5 of the GATT. So it seems to be a much broader type of agreement, although it's only among developing countries and least developed countries. But there hasn't really been specific advice sought on that. And obviously it'd be something that the ACWL will be able to cover for them. But just my closing remarks of that is that the ACWL is a forum that is available for many African countries, because many African countries, 33 of them are LDCs, and also for developing countries who are WTO members. So it really makes sense for partnership and complementarity to be shared, to share best practices and experiences. And really the ACWL looks forward to any partnership that the AfCFTA Secretariat might want to seek out, and also of course with individual state parties that request advice from the ACWL. So really looking forward to partnering with Africa on this really momentous agreement. Thank you very much.
Thanks a lot, Kulu. So I really would want to thank our panelist, Jae Sung Lee from UNCITRAL, Kholofelo Kugler from ACWL, and of course, the Secretary General of the UNCITRAL, Ms. Anna Joubin-Bret. And well, thanks a lot also for the audience. We really appreciate your time and your participation. Thanks.